Okay, we will hear from the appellant.
Good morning, Your Honors.
Good morning.
May it please the court. I'm Evan Johnson from the Memphis Bar, representing the appellant, Ms. Kelly Gullett Thompson, regularly referred to throughout this case as the mother.
Would you pull that microphone down a little bit, please?
Yes, Your Honor.
Thank you.
And I would like to reserve 5 minutes for rebuttal.
5 minutes, all right, sir. You may proceed.
Do not anticipate using all the 5 minutes. Thank you.
You'd be amazed how many people say that.
This, Your Honors, is a termination of parental rights case following a divorce out of Shelby County. The divorce was finalized by final order in February 2nd of 2018. Prior to the finalization of that divorce, appellant was ordered to only have supervised visitation and regular contact with the child via FaceTime as the rights allow. Since approximately September of 2016, appellee filed their petition to terminate appellant's parental rights in February of 2023. Two-day trial was held at the end of 2024, and then a final order entered in October. In that final order issued by the Honorable Joe Day Jenkins from Part 3 of Chancery Court, Shelby County, he found 3 grounds to terminate appellant's rights. 4 grounds had been alleged from the statute, Tennessee Code Annotated 36-1-113. And as Your Honors are aware, that standard is a clear and convincing standard that His Honor found by clear and convincing evidence as to 3 of those 4 grounds that were alleged in appellee's petition.
Let me ask you a question.
Yes.
It's the question that the panelists discussed, or some of the panelists discussed. I note from the issues you've raised on appeal, the only issues you've appealed are grounds.
Yes, Your Honor.
And we have some law, the Carrington case, that requires us to also consider best interest. However, I'm concerned, and specifically what I'm trying to ascertain is, are you contesting a finding of best interest?
I think I understand Your Honor's question. I apologize if I don't. Let me.
Well, are you saying that there was insufficient grounds or insufficient proof presented as to best interest?
As it relates to the getting to best interests once the grounds have been satisfied.
Let's assume that, just for purposes of discussion, that grounds are proven. You did not raise best interest as an issue on appeal.
That is correct, Your Honor.
So consequently, are you agreeing that best interests were proven?
I don't think that I can say that I'm agreeing that the best interests were proven. I think because the statute requires the grounds to be found first, I did not get into the best interests because it's appellant's argument that the evidence did not meet the clear and convincing standard to satisfy the grounds, so never getting to the best interest analysis.
Well, but for the Carrington case, by not raising grounds as an issue on appeal, it would be waived in any other type case.
Yes, Your Honor.
Okay. I'm just trying to figure out what was going on here.
Understood.
So basically, you're putting all of your eggs in the basket of grounds.
That is correct, Your Honor. Based on the evidence at trial, it is my understanding and appellant's understanding from the evidence put forth at trial that the grounds were not satisfied However, assuming for argument that they were satisfied, I don't know that we would have been able to reach the argument as to the best interest factors that were established.
I'm not sure what you just said.
Assuming that the grounds were satisfied, you don't know that you would have been able to reach the best interest, I think is what you just said.
Yes.
And I apologize.
I don't
that was
understand it, though.
Okay.
Hearing it back,
Yeah.
it's confusing to me, so I appreciate. I think what I'm trying to say is that I'm not sure we would have been able to defeat the argument that the best interests were satisfied, assuming for argument that the grounds were satisfied. I'm not sure that appellant would have been able to defeat the arguments that were put forth with regards to the best interest factors in the way that these grounds would have had to have been satisfied. Maybe that answers the question a little more clearly.
But you're not agreeing that best interests were met?
Correct. I'm not agreeing that best interests were met.
Okay. All right. Go ahead.
The main factor that I want to start with, I apologize, not the main factor. The first ground that was found by the trial court to have been satisfied was subsection G1 of the statute as it relates to abandonment for failure to provide support.
Let me ask you a question there.
Sure.
Did you raise lack of willfulness as an affirmative defense?
It was raised at trial as a part of...
Did you raise it in an answer? Because the statute requires an answer.
And there was not, as far as it relates to an answer affirmative defense, and making that, as Your Honor has stated.
Does that mean no?
That means no, yes, Your Honor.
Okay, thank you.
So, I mean, do we even get into that when you didn't raise it as an answer?
My argument would be that because of the nature of the termination of parental rights statute and the needing to go through each of the grounds that, as they were found in the evidence that was determined at trial, my argument would be that we do need to go through the child support, the failure to provide child support ground as it relates to the termination of appellant's parental rights. And so, yes, all that to say, yes. With regards to the willfulness requirement in an operative parenting plan that established appellant's child support obligation as 0, the elements required for willfulness being the awareness of a duty to provide support, the capacity to provide support, and whether or not appellant made any attempts to provide support, and then no justifiable excuse. Those elements were not satisfied with regards to appellant's what would otherwise have been an obligation outside of an operative parenting plan, in this circumstance, parenting plan order.
I thought the proof was that your client admitted that she understood that she wasn't paying child support because she was paying for the supervised visitation, but I think there's references specifically to where she admitted that she understood that if she didn't pay for supervised visitation, she was required to pay child support. Am I wrong about that being part of the evidence?
I do, Your Honor is correct that appellant has stated that she understood why her obligation was deviated, that it was for the purposes of providing, so that she could provide supervised visitation and account for that cost. However, I don't believe, it's best of my recollection, that her testimony was that she understood that if supervision were to stop for any purpose, that would trigger her need to then provide support when an operative parenting plan states that her obligation is 0. And the plan does, as the brief as appellant's brief states, and the trial court's order states, that parenting plan includes language that states that why the deviation was made, but it doesn't have language to then trigger it once a supervision were to cease for any reason, of which there were many in this case, that she would then need to begin making those payments. And it clearly states that the obligation is zero. So that with regards to that ground specifically, it creates this conundrum where she wouldn't be aware of a duty outside of another court order stating that she was now obligated to meet that duty, meet that obligation. As my time has ended, I will step back. Thank you.
Thank you. Hear from the appellee.
Good morning. May it please the court, I'm Laurie Hall. I'm a member of the Memphis Bar. I represent the appellees in this matter, Timothy Justin Thompson and Amanda Brewer Thompson. Before I get into the issues that were raised on appeal by appellant, I want to point out that this matter was heard before Chancellor Jenkins in the underlying divorce. So he had opportunity over the years to observe the appellant multiple times before the court, both during the divorce and after the divorce. There were numerous petitions filed by appellant and by appellee, the father appellee, in regard to the supervised parenting time. And at no point did Chancellor Jenkins expand the biological mother's parenting time. Rather, he put further restrictions on that parenting time. And those observations are reflected in the court's findings of facts in the order terminating the biological mother's parental rights. As it relates to the failure to pay child support ground, the permanent parenting plan included a provision that did deviate the biological mother's child support down to zero, and the purpose of that, as explicitly stated by Chancellor Jenkins in the order, was so that the mother could pay for supervised visits. The Chancellor Jenkins did find, and again this is reiterated in the order, that at the time of the divorce the mother had some earning capacity and so imputed income to her in the amount of $1,733 per month.
Well, this was not raised as an affirmative defense, though, was it not?
That's correct. It was not raised as an affirmative defense.
But was it tried?
I'm sorry?
Did you try it by consent?
It was tried by, I would argue that it was tried by consent because it was not raised as an affirmative defense. The statute changed in 2018 requiring the appellee to plead willfulness as an affirmative defense.
And this was tried in 23?
That's correct. That's correct. And the petition was filed in 2020, or the petition was filed in 2023, I believe, and the matter was heard in 2024. Yes, Your Honor. The evidence also, as the court indicated, is that in mother's deposition, she admitted that she knew she had an obligation to pay for supervised visits, that was why her child support was deviated down to zero. And she basically said that if she couldn't see the child, she wasn't going to provide any child support anyway. So even if willfulness was a requirement, she was willfully not paying child support. As it relates to the second ground, which is the ground of...
Let me ask you, there was actually an amount of child support set, and that was deviated from provided she pay for supervised visitation.
That's correct.
And what was that amount?
$449 per month.
Okay, all right.
And as it relates to the next ground that appellant has raised for an issue on appeal, that's the ground of mental incompetence. That ground states that in order for someone to be found mentally incompetent, the person must be so impaired and so likely to remain impaired that it is unlikely that the parent will be able to resume or assume physical custody, and that termination is in the child's best interest. Here, the biological mother first lost custody back in 2016 when this divorce was filed. my client, the father, sought an immediate emergency injunction based on the same types of behaviors that frankly existed at the time that we went to trial on this termination petition. The court found specifically in the order that the biological mother suffers from the same mental instability, that was exacerbated by Adderall, which the biological mother was also using back in 2016 excessively. And Dr. Leonard performed 3 Rule 35 psychological examinations of the biological mother over the course of the years, both before the divorce was granted and then 2 subsequently, 1 back in, I think, 2022 and 1 in the context of this petition being filed, in which Dr. Leonard found consistently that the biological mother suffered from borderline personality disorder, mixed with antisocial personality disorder, that the Adderall exacerbated her condition, that there was delusional thinking, poor insight, and Dr. Leonard made specific recommendations which the biological mother chose not to follow. Under the law, for the ground of mental incompetence, a person must be able to care for the child independently in the near future. And there was absolutely no proof presented that the biological mother was able to do that. And in fact, she's not been able to do that at any point going all the way back to 2016.
When you
At
say
the
there
time-
was no proof in the record, don't you have that burden of proof?
Yes, Your Honor,
Okay.
and I would submit that Dr. Leonard's report that was admitted into evidence, his testimony, that established clear and convincing evidence of the biological mother's mental incompetence, along with mother's own testimony, frankly, and the testimony of her mother, who testified that the biological mother had even physically assaulted her 2 weeks before she came in to testify at the trial of this matter. So there was more than ample evidence for the appellees, my clients, to prove clear and convincing evidence of the biological mother's instability.
So you're relying upon the psychological reports as well as the testimony of the appellant and her mother?
The testimony of the appellant, the testimony of her mother, the testimony of the father, in this case, my client, Mr. Thompson, and Dr. Leonard, who testified as an expert, yes. And, Your Honor, Chancellor Jenkins even references in his order that he himself exhibited, or he himself witnessed the erratic behavior and unstable behavior in court by the biological mother over the years. The best interest analysis, once it's clear that the appellant has shown that the mother's unable to independently, the appellee has shown that the biological mother is unable to independently care for the child in the near future, a separate, I would argue, best interest examination must take place under that statutory ground. And again, there was ample evidence, the courts laid it out in the order, looking at all the factors. If it is indeed the same factors, our case law is not clear on that, but if it is the same factors the court's to look at independently under the mental incompetence ground, all but the factor that involves DCS, I think it has to do with the permanency plan, all of the factors were shown that it is in the child's best interest that the biological mother's parental rights be terminated.
This was sort of a unique way of doing this, I believe. Did the guardian ad litem present a report on best interest factors?
The guardian ad litem presented a pretrial memorandum that outlined the guardian's position on whether the best interest factors supported termination.
Okay, but the trial court entertained proof on all those factors as well, is that correct?
Yes, and the trial court made specific findings under each best interest factor that was applicable, outlining what proof the court heard to establish that each and every factor was met in terms of supporting termination.
So the guardian ad litem report or pretrial recommendation and the trial court's findings or fact are not the same?
The trial court My recollection is adopted the guardian ad litem's position on the best interest factors, but also made additional findings as it related to the court's findings on best interest.
Okay.
So as to mental incompetence, I would submit that the trial court correctly found that the clear and convincing evidence was established that the biological mother was mentally incompetent, and that it was in the best interest for her rights to be terminated. And then finally, the last ground that was raised on appeal was failure to manifest an ability and willingness to assume legal and physical custody of the child, and that placing the child back in the parent's care poses a risk of substantial harm. And so appellant's argument is that that ground was not proven by clear and convincing evidence at trial. And I would submit that there's ample evidence in the record to support that there was clear and convincing evidence that the biological mother did not manifest an ability and willingness to assume physical custody of the child, and that placing the child in her care would pose a risk of substantial harm. Again, Dr. Leonard made recommendations. The court itself made recommendations over the years, which the appellant did not follow. In the biological mother's deposition, she testified that she thought Dr. Leonard was a quack. She said that she had no intention whatsoever of seeking any further mental health treatment. She, at the time of trial, had suffered a series of strokes, which it appeared, in part at least, to be due to her Adderall use, and that's based on the fact that she was taking more Adderall than she was prescribed, had not followed her doctor's recommendations about dosage or even whether she should stop Adderall after the initial stroke.
Were medical records introduced about that? Or
Yes, Your
medical
Honor.
testimony?
There was testimony about that, both through Dr. Leonard and through her medical records. It was introduced into evidence at court. The court specifically found that the biological mother was not able at the time of trial to provide for the child, whether financially, emotionally, or mentally. Dr. Leonard specifically found, and I touched on this earlier, but that the biological mother exhibited delusional thinking, hostility, poor insight, poor empathy for the child, continued maladaptive personality traits. And Dr. Leonard specifically opined that the biological mother posed a risk of psychological harm to the child. The court found in the best interest factors that appellant's instability was often hurtful to the child, that placing the child with appellant would cause a significant negative impact on the child's emotional, psychological, and medical well-being. And I believe appellant's argument as it relates to this ground is that the biological mother had a willingness, but I would submit that the case law, the In Re Nevea case, indicates it's an ability or a willingness, not an ability and a willingness. And here, despite whatever the biological mother said at the time of trial, she had no willingness, and that's clear from her own statements that she made at the trial court. And so based on all of that, I would submit that the trial court correctly determined that clear and convincing evidence was met for this ground, and that the biological mother's parental rights should be terminated. And so I'm asking this court to please affirm the trial court's finding terminating the biological mother's parental rights. Unless the court has any other questions for me, that would conclude my argument.
See none. Thank you.
Thank you.
If it may please the court, I would like to address the other two grounds as it relates to appellant's argument. First, the mental incompetence ground. that the case law has made it clear that mental incompetence in and of itself is not sufficient to meet the standard of this ground. Dr. Leonard's testimony and report goes in a great deal into appellant's mental capacity and mental stability, of which the court eventually found her mental instability as it relates to this ground. However, it requires more than just that mental incompetence. That the mental condition of the appellant must also create such an impairment that it adversely affects their ability to parent. I think both with this ground, the mental condition of appellant, but also with the third ground, the failure to manifest by act or omission an ability and willingness, it's important to note that again, as it relates to the operative parenting plan, the appellant had been under that operative parenting plan and had not had her ability to manifest that willingness and ability was severely hindered, not only by the court's orders, obviously to some degree, which were based on his observations as it relates to the divorce, but also as there was substantial testimony with regards to the ability to find supervisors. Both mother and father testified at the trial that the ability to find supervisors was very difficult for both of them, as father had also attempted to find supervisors for the
Did the
child.
mother ever approach the court or request relief in any form, or come back for any kind of motion or petition or anything to say, court, I can't find a supervisor, I only have supervised visitation, what do I do?
So there were multiple petitions filed, as my colleague has indicated, prior to trial, and there was a motion filed with regards to finding another supervisor.
By the mother?
By the mother. That motion was not heard, but there,
Was that before or after the petition to terminate?
that would have been after the petition to terminate.
Was there anything she filed before that?
There were, my best recollection is there was not a motion specifically in that regard as far as supervising. However, there were a number of pro se petitions filed by mother prior to the termination petition being filed that sought various things that I believe included supervising either being eliminated altogether or also a different supervisor. The court did hear testimony as it relates to supervision on a number of occasions and had, as previously stated, had restricted that supervision to some degree.
That's my point that I wanted to make just a moment ago, or be sure that I was understanding correctly. The need for supervision, according to the court, was driven by your client's behavior. Correct?
Correct, Your Honor. At least in part, yes.
So consequently, and theoretically, perhaps, the ability to control her behavior resided with your client, who could have remedied the need for supervision, again, theoretically.
Correct, Your Honor. Theoretically, yes. I think what mother had demonstrated throughout the course of the proceedings as well as at trial was her willingness inside the restrictions that had been created, somewhat based, as Your Honor has stated, on her conduct and her behavior, to continue to have a relationship with the child as her parent and be able to continue as her parent moving forward. And not a situation where, for one, the ground with regards to abandonment for failure to visit was not found, I think, which is instructive of there was a continuing relationship that she was, at that time, that was as much as she could get because there was no supervisor, and she was regularly making those as best that she could. And so I would ask that the court vacate the trial court's ruling, and thank you.
And you used your full 5 minutes.
I did.
All right, thank you, counsel. We will attempt to take this matter under, well, we will take it under advisement. We'll attempt to get you an opinion as soon as possible. Appreciate your argument. Thank you for being here today, and you may be excused.